let me then begin, because otherwise we'll lose track. And as I have only 40 minutes to go per
Right.
session because of the system, it's better that we go. Thank you for joining, Pearl. I will first start with your question. There were 3 questions raised. You can find those questions on the screen. There you go. They are on the screen here.
Yeah.
Your question is here on countermeasures.
Right.
Is countermeasures considered a form of self-defense by the injured state and a reaction to the wrongful act? If it is, why is it considered intrinsically illegal? Very good question. Now, the countermeasures and self-defense are both forms of self-justice, in the sense that you use them unilaterally without referring to anybody else. You decide to use them. Hello, everyone. Abdi, welcome. Do you hear us? You probably hear us, but I don't hear you, Abdi. And Muda, welcome, Muda. Do you hear us? Okay.
We can't hear him.
We can't hear you, Muda. But
hello.
Hello. Yes, we hear you.
Hello.
Hello, Muda.
Yeah, I can hear you too. Hello. Good evening.
Good evening. Where are you joining from?
I'm from Syria.
Okay. And you are joining from Syria now?
No. Now I just arrived Iran, so I'm now in Iran.
Okay. Be very welcome, Muda.
Thank you very much.
Thank you for joining. Pearl is from the United States, in Florida. She joins us. And then we have Abdi, but Abdi, we don't hear you. Can you speak? Oh. Abdi, I'm sorry, Abdi, you will have to, maybe your computer, but please stay on. We won't hear it. You can write the keyboard, Abdi, if you want to interact with us. You can use the keyboard, okay? So be all welcome. I was addressing a question by Pearl, and the question is on the website of the course. Is countermeasures considered a form of self-defense by the injured state and a reaction to the wrongful act? If it is, why is it considered intrinsically illegal? I don't know if you are already there in the course, but Pearl, your question, if you gentlemen, you are already addressing countermeasures and self-defense in the course, but your question, Pearl, is indeed very good. Because the 2 institutions of countermeasures and self-defense very much resemble each other. Now, because there are 2 ways for states to protect themselves and to make justice for themselves. Those are 2 forms of self-justice. However, and also a similarity between the 2 is that you may remember in the articles on state responsibility, they are both considered as circumstances precluding wrongfulness. Okay? Now, the difference between self-defense and countermeasures is that self-defense are a use of force in reaction to an armed attack. Okay? Countermeasures, you cannot use force as a countermeasure. You can only use non-forcible means under the law of countermeasures. And self-defense is a circumstance precluding wrongfulness, because the use of force in international law as such is prohibited. That is Article 2, Paragraph 4 of the United Nations Charter. So self-defense is a use of force, which is not illegal, because it is a reaction to an armed attack. Okay? if it is not a reaction to an armed attack, the use of force cannot be said to be in self-defense, and then it would be illegal use of force.
Okay.
You see that?
Mm-hmm.
No,
Yeah.
of course, I don't know if you, Pearl, I don't know if you are already in week 8. Have you?
No.
You will see in week 8 the discussion about self-defense and the conditions to resort to self-defense, and notably the issue of what is an armed attack. What is the threshold of gravity that you need to reach to be the victim of an armed attack? And also a very, very difficult and very contentious issue is whether you need to wait for the armed attack to occur before being entitled to use force in self-defense, or if you can use self-defense preemptively in advance of a foreseeable armed attack. And that's a very contemporary debate. It's a debate that has been going on in legal doctrine for many, many years, and states have different views on that. And there are many explanations on that issue in week 8 when I speak about the use of force and self-defense in international law. But I would say that self-defense and countermeasures are very similar to each other in the fact that those are self-protection measures, that they are self-justice measures, that they are circumstances precluding wrongfulness. But the difference is that you need to limit the notion of self-defense to forcible measures, measures that use force, armed force, and limit countermeasures to measures that do not use force. Okay. And of course, if you are the victim of an armed attack, you can use self-defense, or you can use countermeasures also. If you are not the victim of an armed attack, only countermeasures are available to you, because you could not use force in self-defense if you're not the victim of an armed attack. Okay, so those are the differences, and I hope the differences will be even clearer when you go through week 8 on the use of force. Okay.
Okay, I'm putting it in my notes.
Yes.
Yeah, I have a question. I'm just week started for. Are you hearing me?
I don't hear you, Abdi. Mudar, I don't hear you.
Yeah, can you hear me now?
Yes, I can.
Okay, I have a question. I'm in week 2, and I'm now studying the elements of statehood.
Okay.
Yeah, we study the elements of statehood as there are 4 elements of that characterize a state.
Mm-hmm.
The 4th element is sovereignty.
Mm-hmm.
Okay, is it included in the effective government, or is it legally wrong to take sovereignty as a 4th element of the statehood?
You mean whether the 4th element, which is the capacity to entertain international relations?
No, I mean here in Syria, we study the sovereignty as an element of a statehood.
Yes.
Is it the same as effective government, or is that legally wrong? I'm talking legally speaking.
Okay. If you are a state, you are sovereign by definition. The question is to know, what does it take to be a state? Yeah. And you cannot say, well, it takes sovereignty to be a state, because sovereignty is what goes with statehood. So what do you need to be sovereign is to be a state. And what do you need to be a state? And there you enter in the 3 or 4 elements theory: territory, government, population. Okay. And if you have those together, then you can identify the entity as being a state. And if that entity is really a state, then by definition it is a sovereign state, because you don't have in the status of nature, if you want. You don't have state, or in the natural status of things in international law. You don't have states that are not sovereign. Okay, states may limit their sovereignty. For instance, the 28 member states of the European Union have decided to commit themselves to limit their sovereignty, because they can't, for instance, the member states of the European Union, they may not contract treaties on trade anymore, for instance. Those treaties must be contracted by the European Union, okay? So in a way, those states are less sovereign than, and tomorrow when the United Kingdom gets out of the Union, the United Kingdom with Brexit, the United Kingdom will resume being fully sovereign with all the capacity to contract treaties on all matters. Okay, but remember the theory of international law, which says the treaty limits your sovereignty, but at the same time the treaty is an exercise of your sovereignty, because the treaty only exists because you consent to it, and consent is an act of sovereignty. You are free to consent. You may not consent. Okay, but I would not characterize sovereignty as a condition for statehood. Sovereignty is not a condition for statehood. Sovereignty is what follows from statehood. You see, if you are a state, sovereignty goes with it. Okay. But it's not a condition for statehood. It is the result of statehood. And statehood is factual. Are you capable of establishing yourself as a state vis-a-vis other states with a territory, a population, and an independent government? That's really the issue.
Okay, that's clear. Thank you.
Okay, is that helpful?
Yeah, that's yeah, so helpful. Thank you.
Of course, I you know, from the region in the Middle East, of course, maybe a question looming large in the mind of many people is whether the Islamic State, so-called Islamic State Daesh, is a state or not. It calls itself a state, but is it a state or not? I think it's too soon to answer that question. Obviously, it tries to establish itself as a state, but effectively it is fought by many other states, and many other states don't want that entity becoming a state. And also, if you think about it, and if you look at the purposes and the aims of that entity, they do not, I mean, they claim to be a state, but they pretend to also represent something much bigger than a state, which is the community of Muslim believers around the world. So it really goes beyond what statehood is about. Okay, they are not taking charge only of themselves and of their population, but they pretend to exercise authority of many other states, which is on many other people around the world, which is very self-contradictory with the notion of the state. The state is about a population in a territory and not about everybody else in the rest of the world. I mean, the Catholic Church, historically, the Catholic Church has also has never pretended to be a state, but has pretended to be an entity under international law, and the Catholic Church purpose is saving the soul of all the Catholics around the world, which has nothing to do with the duties of a state. It's something different than looking after a population and being worried about the population in a territory, in a given territory. Okay, so
so on that subject, as I see it, the population of ISIS is not an they are more like prisoners than they are a population. They are all escaping. So
sure.
Legally speaking, can that be a clear answer whether the state of ISIS the state or not? I mean, if the population is forced to be in the state.
Yeah, I think the very that's also an element that you see in the course when I refer to the Kosovo advisory opinion. When the conditions that give rise to a state are so fundamentally in breach of fundamental norms, when the state is the result of an illegal invasion, when the state is the result of grave breaches of international humanitarian law, etc., etc., the practice is that we cannot recognize that entity. There's a rule under general international law prohibiting recognition. So other states may not consider Daesh as a state because the conditions, the condition that brought Daesh to existence are so outrageously in breach of international law that from those breaches no legal entity can ensue, no legal entity can be born out of those breaches. Okay, and other states have an obligation. And there's what is interesting is that at the Security Council, there's not a resolution of the Security Council saying that you may not recognize Daesh. It never crossed the mind of any other state to recognize Daesh as a state. Nobody thinks that way, okay? There is a Security Council resolution saying that you may use all necessary means to eradicate Daesh. And that could not be the case if Daesh were a state, okay? So it's quite
Yeah.
You think?
Okay. Yeah, it's quite clear.
Welcome, Manuabe. Be welcome. We don't hear you. We don't hear you. You need to put your microphone. Manuabe, welcome. Put your microphone if you want.
You can't hear.
Hear me now?
Yes, we hear you a little bit. You can.
Okay, let's try to increase the volume.
Okay, be welcome. Be welcome.
Thank you. Thank you.
I've already addressed the first question. Let me proceed because I have only 40 minutes together. I've already answered a question by Pearl, and the question was on the difference between self-defense and countermeasures. As I see you are there, Manuabe, I think this is your question. Could you please, is that right on your screen? Could you please explain with illustration or example the concept?
Explain
Sorry?
Object and the concept of object
and purpose. Okay, I'm just reading out. I'm reading out for everyone your question, and the question appears on the screen. Could you please explain with illustrations or example the concept of object and purpose? For example, a treaty with respect to invoked material breach, and of an organ such as the of the ICJ.
ICJ.
Okay, I think I got it, but at times I'm not so confident of my understanding of the concept. The concept I found that is very important to grasp. Thank you for your question, Manuabe.
Thank you.
It's an interesting question, and I'll give you some examples. Where are you calling from?
Canada.
Oh, Canada. Okay.
Canada.
You're welcome.
Yeah. Thank you.
Let me give you a recent example, an interesting recent example on material breach and object and purpose of the treaty. Let me bring you to a recent case. This is the website of the Permanent Court of Arbitration, and among the recent cases of the PCIJ, you will find this case, arbitration between the Republic of Croatia and the Republic of Slovenia. That's an arbitration about the land and maritime border between Croatia and Slovenia. Okay. Now, those two states are no members. Yes. Today, they are members of the European Union, but before Croatia joined the European Union, the Union asked them to have an arbitration about their dispute, maritime and land border dispute. And the arbitration has been going on.
Yes.
But there was an incident during that arbitration because the arbitrator appointed by Slovenia had relations and had telephone conversations with the representative of the Slovenian team, with the agent of Slovenia representing Slovenia in the case. And that should not be done. This is really in breach of all types of, procedural rules. If you are a judge, you don't speak to the counsel of the parties. If you are an arbitrator, you don't speak privately and discuss the case while the case is pending and while the case is being deliberated by the arbitration. And strangely, in the news in Croatia, in the newspapers, appeared the telephone conversation between the Slovenian arbitrator and the Slovenian agent. So it was a disaster for the arbitration. And Croatia decided to terminate the arbitration. And Croatia said, well, this arbitration is rigged. It cannot go longer, and I'm terminating the arbitration. Now, the arbitration was set up under a treaty for arbitration. There was an agreement to arbitrate between the two parties. And to know whether Croatia had the right to terminate the arbitration, the arbitrators had to decide whether there was a material breach of the arbitration agreement and whether that material breach related to the very object and purpose of the arbitral agreement. And in the partial award that you find here, that's the partial award of June 2016. In that partial award, the tribunal decided that yes, indeed, Slovenia had breached the arbitral agreement. That was in violation of the arbitral agreement. However, the tribunal decided that it is a breach, but it is not a material breach defeating the object and purpose of the treaty. The arbitral tribunal considered that the arbitration could still go on despite that breach, that breach was not, it was a grave breach, but it did not defeat the object and purpose of the arbitration agreement, so that the arbitration could go on. You see? So that's a recent example. Let me bring you have questions about that example?
Yeah.
Gentlemen?
Yes, please. Yes, please. Yes, please. In this particular example that you just used, which would be the object and purpose of this dispute?
Well, the object and purpose of the dispute, was the settlement of the land and maritime border. But the issue is not about the object and purpose of the dispute. The question is about the object and purpose of the arbitration agreement under which the dispute is being disputed. Okay, and the court and I don't want to bring you too much into details, but if you go through the arbitral award, and if you go through that award, you will see the discussion by the tribunal of object and purpose of an arbitral agreement, and what is the object and purpose of an arbitral agreement, etc., etc. If you look at paragraph 2119, for instance, the treaty in question is of a specific kind. It is an arbitration agreement. And then they review what is the object and purpose of such an agreement. You see? I would like also to draw your attention. Object and purpose of treaties are very important matters.
That is good.
Okay?
Yeah, that is good.
I'd like to bring your attention also to, and this relates to week 4, reservations to treaties. You remember you may not make a reservation if the reservation runs against is incompatible with the object or purpose of the treaty. Okay. At the ICJ, This is the website of the International Court of Justice. Okay.
Yes, yes.
If you go to the cases, list of all the cases, there's a very old case, a very old advisory opinion of the court of 1950 about reservations to the Genocide Convention. You know, there's a Genocide Convention of 1948, and that convention includes an adjudication provision giving jurisdiction to the ICJ. At the time, the Soviet Union wanted to join and wanted to sign in the Genocide Convention, but the Soviet Union refused to give jurisdiction to the ICJ. And so the Soviet Union made a reservation about that adjudicatory, the provision of the treaty which give competence to which give jurisdiction to the ICJ. And the question was to know whether that reservation is valid or not. And so the court had to assess what is the purpose, the object and purpose of the Genocide Convention. And the court said the object and purpose of the Genocide Convention is, as the title reads, the prevention and punishment of the crime of genocide. But the object and purpose of the Convention of 1948 is not adjudication between states. It's the prevention and punishment of the crime of genocide. Therefore, if you sign in the convention, but you refuse the provision of the convention which relates to ICJ jurisdiction, your reservation about ICJ jurisdiction is valid. It does not run against the object and purpose of the treaty. Okay? So that's another example to illustrate how important it might be to identify the object and purpose of the treaty. Okay? Does that help you?
Thank you so much.
You're welcome. Now, I have 6 minutes to go.
Thank you so much.
I have 6 minutes to go. Abdi, I'm going to take your questions quickly. Your question, Abdi, is a very large question because you, let me bring the question on the screen for everyone. The question is here. Future changes in international law. What changes must international law make in the future to adapt to the new times in which multilateralism is being replaced by unilateralism? A very interesting question, very difficult to answer. I would say, from a positivist perspective, if you describe international law as it is, well, international law is what states make of it, okay? So if states turn out to be more unilateralists than multilateralists, of course, international law will recede, and you won't see many multilateral treaties being concluded in the future. And in the 1990s, it was a big era of multilateralism with WTO, ICTY, and other international organizations being set up. Now, you have to keep in mind that I think, very purpose of international law is cooperation and coexistence between states. And cooperation between and coexistence between states may take the form of multilateral treaties, and that sometimes states will like to depart from multilateral treaties, and if they don't want cooperation anymore, then those multilateral treaties will not really be abide to or will be replaced. But you must remember also that when you have multilateral instruments, when you have those treaties in place, and when those treaties provide for various mechanisms for settling disputes or enforcement mechanisms, institutions are resilient. Institutions are resilient, and they may, you know, stay there longer than certain governments that are elected for 4 years or 5 years, and in that period of time, maybe those governments don't really have the time to change the whole system, and that's why multilateral instruments, I think, will survive on the long term, even if politically sometimes they are a little bit put in jeopardy by certain national politics. Okay, but I mean, let's see. For instance, in the United States with President Trump, he says if the US has an adverse ruling at the WTO, he says he's not going to abide WTO rulings. Well, there are mechanisms at the WTO by which, if the United States loses a case and does not abide, well, other states may take measures against the US, raise tariff barriers, etc. And so other states, the winning party may hit under the law in order to force compliance. And we'll see, okay, how things develop. And maybe states will come back to multilateralism because it's just simply impossible in this time and age to live on your own. There is interdependence between states. So that is my, and it's a fact of life. That would be my answer. Okay, Mudar, I just saw your message about turning down microphone.
They did though. They did so. Thank you all very much.
There is Ivo is with us. We don't see you, Ivo. I don't know if you hear us.
Yes, hi, I'm here. Can you hear me?
Oh, but that's Manuabe. Okay. But I thought there was a fifth person joining called or sixth person joining, Ivo. Well, anyway, ladies and gentlemen, I have 2 minutes to go with my video, which can only run for 40 minutes. I don't know if you have additional questions for today. I'll set up other meetings, of course, along the course. I have another meeting tomorrow morning for another time zone, but you are welcome to join also if you want. Very little time left if you want to answer, to raise a question. I'm sorry about that, but there will be other meetings, and you can always send questions on the website for next time, and I'll try to address those. Okay?
Okay.
Thank you very much for joining. I hope you're enjoying the course. I hope to see you for another conversation next time on video. I'm sorry the system only allows us to have 40 minutes of exchange. But thank you very much, and be safe wherever you are.
Thank you.
Thank you.
Thank you.
Thank you, Abdi. Abdi, I hope we can fix your microphone for next time. Okay.
Yes.
Goodbye.
Goodbye.
Good night.
Thank you. Bye-bye.